Your Honour, the defence will humbly submit an application for the exclusion of evidence brought by the prosecution on the basis of substantial non-compliance with the Police Powers and Responsibilities Act, in line with Section 130 of the Evidence Act and Section 590AA of the Criminal Code. Your Honour, there are 106 charges against my client, who is a Torres Strait Islander juvenile. When arrested by police, he was charged and taken into custody, questioned at the scene, and then was taken back to the station where he underwent an interview. This interview forms the basis of the Crown's case, although there was no recording and no notes made of the interview. Your Honour, for these reasons, the defence asks that you exclude the interview from evidence. The defence's second argument relates to the actions taken by the police. Your Honour, my client was taken into an unmarked police car and driven around the neighbourhood. Police pointed out houses that had been robbed and asked if he had committed the robberies. At this stage, my client's parents had not been contacted, despite him clearly being a juvenile, which is anathema to the Police Powers and Responsibilities Act and the Police Powers and Responsibilities Code, as I will discuss further in a moment. He was then taken back to the station and into an interview room, still with no parent or guardian present or even having been contacted by the police. There was a support person present at the interview in which my client gave full admissions. However, Your Honour, this support person was not known to my client and told him to just tell the truth and answer the questions. The evidence my client then gave is the basis of the case against him. Your Honour, the police would clearly have been aware that they were dealing with a juvenile and that there were accordingly very strict statutory requirements that they had to fulfil. Instead, they breached these requirements. The Police Powers and Responsibilities Act, Section 421, sets out special procedures for questioning minors, including that a child should be allowed to speak privately to a support person and that the support person should remain present throughout questioning. There was a support person provided in this case, but not an independent support person chosen by the juvenile in question. My client could have had his mother, his father, his auntie or uncle, his grandmother or grandfather present in the examination room, but instead had a stranger who told him to tell the truth and just answer the police's questions. My client therefore did not know that he could exercise his right to silence, as shown by his regimented conduct throughout. On top of this, Your Honour, the Police Powers and Responsibilities Act clearly sets out standards for the questioning of Indigenous people in Section 420, including the need to notify legal aid and the provision of a support person for the Indigenous person. These standards are for the interviewing of adult Aboriginal and Torres Strait Islander people, so the standard would be even higher for children. Yet in this case, the police did not meet the relevant requirements. Your Honour, this conduct is not in line with the responsibilities of police. Looking at the Police Powers and Responsibilities Code, as per Schedule 9 of the Police Powers and Responsibilities Regulation, we see Section 23, which gives the right to communicate with a friend, relative or lawyer. We see Section 25, which lays out standards for questioning of Aboriginal and Torres Strait Islander people. And we see Section 26, which declares a police officer must caution a relevant person about the person's right to silence and ensure that they understand. Again, these standards are for adults, so should be even more stringently upheld in cases of juveniles. But despite this, they have not been complied with in this case. Your Honour, the law is there for a reason. If we look at the purposes of the Police Powers and Responsibilities Act contained in Section 5 of the Act, we see in subsection E that rules governing police powers and responsibilities are there, and I quote, to ensure fairness to and protect the rights of persons against whom police officers exercise powers under this Act. I therefore humbly submit that the interview be excluded from evidence, as to allow it would undermine the fundamental purposes of justice and fairness on which the law is based. Your Honour, After considering the relevant sections of the Police Powers and Responsibilities Act and Police Powers and Responsibilities Regulation, I would ask Your Honour to exercise the bunning and cross and Crown against Ireland discretion and not admit the interview of my client into evidence. This is further supported, Your Honour, by the recent case of the Crown against Saylor, reported in 2012 in the Queensland Court of Appeal at 246. This matter was considered by President McMurdo and Justices White and North in a case where the failure of police to follow provisions in the Police Powers and Responsibilities Act for the questioning of a Torres Strait Islander was at stake. While in that case the appeal to exclude evidence was unsuccessful, the similar principles in the matter at hand today, coupled with the significant fact that my client was a juvenile, meaning that the standard for protection should be even higher, means that the interview should be excluded from evidence today. If Your Honour finds the sections of the legislation have been breached, the Court could exercise its inherent discretion as per Bunning and Cross and the Crown and Ireland, and not allow the record of interview into evidence against my client. Your Honour, there is no further evidence against my client but for this interview, which adds weight to my submission. As Your Honour pleases.